Good afternoon, everybody, and welcome to today's webinar on new sentencing guidelines. My name is Ben Pollard, and I will be looking after the technical aspect of this webinar today. You will notice a chat box in the top right corner of your screen. Should you have any technical issues during this webinar, you can ask any questions and I will respond directly back to you. Please, can I ask that you refrain from sending messages in the chat box unless they're to do with any issues you are having. I only say this as the chat box can get quite busy otherwise. Your speaker today is Steffan Groch, who is a partner and head of regulatory at DWF. Steffan qualified as a solicitor in July 1995 and since that time has advised companies, directors and managers in respect of a variety of health and safety and environment prosecutions. In conjunction with his team, Steffan advises on health and safety systems and procedures with a particular emphasis on crisis management, corporate manslaughter and corporate governance, and he is here today to provide you with an insight into the new sentencing guidelines. You will notice a separate Q&A box in the bottom right corner of your screen below the chat box. If you have any questions for Steffan during the session, please ask your questions in this box. Steffan will then try to answer throughout the presentation where possible and will also tackle any at the end of his presentation. Should we run out of time and be unable to answer all of your questions, we will provide written answers that will be emailed out after the webinar. I shall now pass you over to Steffan and hope you all enjoy the session.
Good morning, everybody. Rather good afternoon, 12:30. Okay, I can see that there's quite a lot of you online. So obviously is the future of seminars and such like, doing them online. I have to say, from a presenter's point of view, they are a little bit unusual, so bear with me. Those of you who have seen me talk before, I do like to make things interactive, which obviously in a webinar is rather difficult, but I know that you've got your Q&A session, so you can post questions as we go along. I'll try to answer those questions if they appear to be timely at the particular point in my presentation. If I don't answer the particular questions, then hopefully I'll be able to pick up a few of those later on at the conclusion. So hopefully everybody is online. I know there's a few people joining as I speak, but I'll crack on and start with the talk. So I'm going to run through a few things. Obviously the new sentencing guidelines, a little bit on fee for intervention, a little bit on reputational crisis management, and a little bit in terms of individual liabilities and how the sentencing guidelines have affected those. Okay, so starting now really with the sentencing guidelines, it is the topic of the moment. I've just had a few chats there. I can see that a couple of people can't hear me talking. Hopefully most of you can hear. If you can't, then by all means let me know. The legal issues, challenges and practical problems for employers in the sentencing guidelines regime, there are many and varied, and what we have seen already in the course of the 17 days since they came into force are a number of inconsistencies in terms of how they are being applied, which is ironic because the guidelines were intended as providing some form of framework for consistency. However, that we are seeing inconsistencies, and we are also seeing some challenges that the courts are having in terms of how to approach the thorny issue of turnover, financial standings of the employers themselves. But in terms of what the guidelines present in terms of legal issues, they are there's a number of them. The first and most obvious one, as I've mentioned, is the subject of the financial position of the defendant. The starting point in the guidelines is pretty clear. They're looking at turnover, but of course, what is turnover? How is that relevant to a defendant's ability to pay? So the legal issues around turnover start in terms of trying to identify, well, what is the turnover of the employer is the employer, for example, in a group structure. Is the employer the individual company within a group, or is the turnover the combined turnover of the group itself? Well, the principle of the sentencing of defendants is essentially to bring home the message of health and safety, so that it's felt by the stakeholders, felt by the shareholders, felt by perhaps the individual, the board themselves. So if, for example, a group structure exists whereby the main board, the board who are the decision makers, are separate, so there is a limited company structure, but then a group structure, and the main board are essentially the board who provide some corporate support in terms of HR, financial, and such like to the subsidiary companies. Then a fine simply based upon the subsidiary company's turnover and perhaps is not necessarily going to hit the group in a way in which the sentencing philosophy is intended to do so. So it's going to create some tension, I believe, and from a legal point of view, on the concept of what's known as piercing the corporate veil. In other words, at what point is a limited company part of a group? Essentially, the group itself. So will the prosecution increasingly be advising the court and asking the court to consider, should the group accounts be considered also? Perhaps not as the starting point, but as part of the overall assessment of, is the level of fine which they've arrived at by virtue of the starting point and then various mitigating, aggravating factors, culpability and such like, is the end point fine actually the right level of fine for a subsidiary company of a group which turns over many multiples of the subsidiary company's turnover? So that is going to be a legal issue that we're going to see, I anticipate, increasingly. It would be, I think, naive to take the view that the courts will disregard the overall group. I think it would be sensible for most defendants to have in the back of their minds the chance that group accounts, the bigger picture, as it were, will be taken into consideration by the sentencing judge. Whether and when we may see the Court of Appeal consider this particular point is a matter for debate. I can't help but think at some stage the Court of Appeal are going to have to look at this particular point again and perhaps provide some clarity. So legal issue number one, what is turnover? Is it a limited company, a subsidiary company? Is it a wider group? Is certainly something already we're seeing. Secondly, culpability. The guidelines talk about culpability in the sense of high, medium, low. There is an analysis required, an agreement required to be made by prosecution defense, if possible, in terms of the level of culpability. That in itself will create more Newton hearings, which are essentially trials within a trial, or a trial on a specific fact or a set of facts. The difference between medium culpability, low culpability in a fatal accident, prosecution, conviction, sentencing could be significant. And therefore, whether culpability is low or whether culpability is medium or even high is going to be something worth arguing about. So the culpability and legal issues around that is going to be something we will see played out within the courts. But there is a third legal issue I wanted to bring to your attention, and it's this. Under the guidelines, they talk about what is the likelihood of harm as part of the essentially an analysis of, if you look at the guidelines as a matrix, and on one side you've got culpability and the other side you've got the likelihood of harm. Now what this has done is really rather interesting. Under the old sentencing regime, it was very much based on an outcome. And what I mean by that is, if there was a fatal accident, then that was the outcome essentially, and the sentence was based upon the death, causation of death. If there wasn't, and for argument's sake you, as we often did, tried to reach an agreement with the prosecution to exclude the fatal accident from the offence for which you're being sentenced. So we often use the expression a technical breach or a non-causative breach. The intention in doing that would be to say to the sentencing judge, look, you don't need to worry about considering the outcome of the death because we have agreed with the prosecution and they accept that the failures didn't cause the fatal accident because, for argument's sake, the employee went on a frolic of his own or a number of other factors. So we argued that non-causative, and as a result the level of the fine would drop considerably, many times. So that was based upon the outcome and causation. The new guidelines, what they ask us to do is to consider what's the likelihood of harm. So if we go back to our non-causative technical breach, or say working at height, it is difficult to conceive a situation where working at height does not in itself involve a significantly high likelihood of harm. Working at height, obviously, you could fall, doesn't take a huge amount of distance for you to turn and revolve on your axis and land at a point where you may well suffer very serious injuries or will die. So the likelihood of harm on a technical breach working at height is high or very high. And so we may find a situation whereby even on a technical non-causative breach, the likelihood of harm and the bracket within which that sits could either be bracket number 1, which is serious harm or death, or bracket number 2, which is obviously less so. So there is a really interesting legal issue there. I was talking to a QC about this yesterday, and we were a little confused in terms of how this is actually going to play out, because if you do have a non-causative case, and essentially what you're saying with the prosecution is, look, this is obviously a breach, and there could have been more done regarding working at height arrangements. However, that did not cause that particular accident. So the actual basis of the breach, the basis of the offence itself, was not actually causing any injury or so. We want to be able to say to the judge, don't worry about this, as it's not a serious case, and actually you don't need to worry about the level of harm occasioned. But actually what the prosecution may say is, well, it's not about what was occasioned, it's about what was risked. What was the likelihood of harm arising from the breach itself? So we could end up being a bit of a circular case here, whereby even if we show that the accident was nothing to do with the particular breach in question, we could end up in a situation where the prosecution say, well, yes, but actually it could easily have happened. So that's a legal issue which we are, I think, increasingly going to see played out. So a number of challenges, and this isn't just challenges for, I should say, for the defendants, this is challenges for prosecution and defence, and indeed the courts. Challenges are, well, how do we deal with all of these questions, these new questions? Guidance is wonderful, but where the guidance is requiring us to analyse additional things, such as likelihood of harm, such as culpability, such as the financial position of the defendant and their ability to pay and their turnover, these represent challenges not just from a point of view of what is required to be considered, the time to be taken to consider. So how long are these going to take in court? Is the court time going to be used up looking at the financial position? Are we going to see more accountants' reports being prepared in order to analyse the financial position and the impact that a fine of, say, 2 million, 3 million, 1 million, or even £500,000, what is the effect of that going to be for this company? What's its liquidity, such like? So The challenges for the courts in terms of dealing with these are challenges for prosecution and defence in terms of providing the courtroom with assistance, additional evidence upon financials. I think we'll also see additional evidence being introduced in order to deal with those areas I've identified, the level of culpability, the likelihood of harm. I think we'll also see additional evidence being brought certainly by the defence in terms of the overall impact that the breach has had upon the company. So that there's no doubt in my mind, and indeed no doubt in the minds of a number of my colleagues, that the effect of the sentencing guidelines will be to create at least one or two more hearings in a typical case, and that's going to involve more delay. Quite interesting. I was invited to present some observations to the Select Committee on Justice during the time after the close of the consultation on these guidelines, and I made it pretty clear at that stage that I felt that the impact of the guidelines would be to cause delay in sentencing, and probably as a direct result of that, there will be more costs incurred, I should say, by prosecution and defence. So it will be a more costly exercise overall, and it will be a slower exercise. So, but the observations from a number of the MPs that were there was, well, if the net effect, or the indirect effect, I should say, of higher fines is it taking a little longer, or more legal fees being incurred, then perhaps that's the price that has to be paid. So there wasn't a huge amount of concern in that regard, but we'll see, I think, in due course, how long these things are taking, how much longer they do take, and whether actually the victims' considerations are taken into account, or whether we enter into the usual legal exercise of looking at culpability, looking at likelihood of harm, looking at the financials, and we all get very fixated by those important aspects, then perhaps the victims, and actually who's been injured and the effect it's had upon them, may well become a bit of a sideshow, which would be, I think, a shame, because it's always the case. I find that in health and safety cases, these things take such a long time to come to court, and you can't help but feel that the victims and those who are injured, or even those employees who witnessed something happening, that their observations, the impact upon them, it becomes rather of an afterthought. So practical problems for employers, it becomes, I say a little bit, as repeating myself to a certain extent, they're going to need more evidence around the level of culpability. A bit more expert evidence, I think, will be required. I think it's also very difficult as well when you're advising an employer, or when, for example, a number of you on the call, I'm sure now, will be asked to present to your board and to give them a steer in terms of, okay, well, this incident's just taken place, or what's going to be the effect of these guidelines. It's actually rather challenging, because you look at the starting point within each of the various sections, be it micro, small, medium, large, very large. You look at the starting points and the brackets within which the potential fines could be, and there's some quite big differences. You know, 1 million to 3 million, or 5 million to 10 million, or 300,000 to 1 million. So it's quite a big gap between what could be on one side a good result, lower level, and what would be a less good result in the higher level. So the practical problems is often, well, I know that I see these guidelines, but actually, what are we going to be in for here? I could have far easier 6 months or so, a year ago, 2 years ago, if an company said to me, okay, we've just had this fatal accident, what do you think we'll get? It probably would have been something along the lines of, well, about 250, 400, 500, possibly if you're unlikely to be less than 100 because of your size, which felt like a lot easier advice to give, I'm not talking about it easier in the context of the level of the fine, but easier insofar as being able to put a number on it. Now I'm giving a number which could be, well, gosh, it could be anything between 1 and 5 or 1 and 3 million pounds. So that I think is a practical issue for not just for the lawyers, but practical issue for those who are being asked to give some advice to the board in terms of what are the implications going forward. And the implications are bigger fines, but actually how much bigger? 17 days on, we are starting to see some decisions flowing through the courts. There have been a couple of large ones, and there have been quite a fair number of smaller companies who also have had recent sentencing. So there's a fair number, and of course the usual rules apply. The HSC's website, the newspaper's press release gives you an ongoing, essentially ready reckoner of all the new cases that have come through and the ones which are being prosecuted. There's a few I wanted to bring to your attention. The one case I wanted to talk to you about was a case up in the northwest, and it involved it was quite a nasty potential, and it was a company called Solvay Solutions, and they were fined a couple of weeks ago now, and the level of the fine was quite significant. It was £333,000. So obviously you can tell there must have been a 1/3 discount for a guilty plea. And then £110,000 in terms of costs. This was a guilty plea. So one imagines the third discount was from £500,000, taking it down to 333 plus the costs of 110. Nobody was injured. There was a potential in that it was a gas release, and a large number of people were asked to stay indoors for a number of days. A number of hours. And it's an interesting case, and it goes back to the point I made, and that the outcome of this was people being disrupted and inconvenienced. There was nobody, as I said, who was actually injured, if there were. Certainly it hasn't been reported in, as far as I can see. It was the potential, the likelihood. £500,000 reduced by a third. Is quite a significant fine for it's essentially a potential rather than actual. So that's one thing that's interesting about it. The other thing that's interesting about it is actually the magistrates handed down the fine as opposed to the Crown Court. It's not something I really anticipated I'd see, if I'm honest, the magistrates handing out significant levels of fines such as this. And it may well be it was a stipendiary, in other words, a legally qualified, essentially district judge. It may well be that that's the case. But I say a couple of interesting points. One is a large company, admittedly, £500,000 reduced down at a third to 330, chunky costs in the magistrates as well. Another recent case wanted to bring to your attention is a case where it was actually a corporate manslaughter, and it was a corporate manslaughter case that was brought against a care home. The care home, in fact, had gone out of business, was no longer trading, but it was nonetheless a significant fine in relation to that particular care home. And the significance always is where you're looking at large fines being handed out where something is not being traded. There's no longer being traded. It gives you a clear steer that what the courts are trying to do is give messages as opposed to sending messages via the amount which they're sentencing. So I'm just trying to locate it on my iPad as I'm sat here. Of course, typically just when you want to find it, you can't find it. So I'll give everybody the note. The name of the company, here it comes. iPad is trying to find itself. Here we go. Sherwood Rise Limited, £300,000 for corporate manslaughter, and that was Friday, a couple of weeks ago now. Was a significant, as I say, significant failures. We also saw some director being sentenced to imprisonment, but essentially the Sherwood Rise was classed as a micro-organisation under the guidelines, but still a £300,000 fine was significant, bearing in mind that they're no longer trading. So there's no question about there are a number of cases that you'll see them on the website of HSE, and you'll see no doubt various solicitors publishing various articles on the cases that they have. There was a very significant fine for the National Grid, also for a large fine for KIP. Unfortunately, it was one of my clients who had the incident. So we are definitely seeing, as we all expected, a large number of high-level fines where we are seeing £1 million here, £1 million there, and it starts to feel like, okay, that's par for the course now. We'll then see it tracking up a little bit more. We'll see a few more in the £1.5 to the £2 million as the courts get more comfortable in terms of handing down these fines. The unfortunate point, and it's perhaps something that the HSE may well become a little bit more alive to as they're reporting, is so it's a little obvious the turnover or the size of the company, because press releases that I see tend not to be making a regular reference to turnover, and it certainly would be useful, I think, for safety professionals to be able to say to their stakeholders, look, here's a company turning over X amount and it was fined X amount. That's the sort of effect of the sentencing guidelines. So I suppose from my point of view, that would be useful. It's also a lot easier, whilst you can go online and do a quick search on Companies House to find out their turnover. I think it would be useful if the press releases are stated a little bit more frequently. So just pausing for a moment there, I see that there are a number of questions being asked through. So we'll start there. Will the training material be available? Yes, it will be. Dale Robinson, a recent branch meeting went in a little more detail on legal privilege. Can you discuss the deal? Yes, I'll pick up on legal privilege towards the end, if I may. Okay, so there's a good question here from Ryan Kershaw. How does the sentencing position apply when a limited company operating in the UK is owned by a larger company based outside of the UK? It's a similar issue, really, in terms of piercing the corporate veil. It's no different, in my view, whether the limited company here, which of course would be prosecuted, so let's say Acme UK Limited, owned by Acme Global. So Acme UK Limited is prosecuted, that's who appears on the summons. If prosecutions say, we know that Acme UK Limited turns over £50 million, but Acme Global turns over £5 billion. If Acme UK Limited says to the court, look, we may turn over £50 million, but we only made £50,000 profit last year, and we really can't afford to pay a fine according to the guidelines, then judge may well say, well, if I did that and I fined you, say, £500,000 and stripped out 10 years worth of your profit, would Acme Global pay that? And if the answer was yes, then you might see a situation where the judge feels more comfortable about handing down that fine because he knows or she knows it's going to be paid by the Acme Global in order to keep that business going. So I think same point really. Whether or not it's based outside of the globe, the group company is based outside of the UK or inside the UK, I don't think it really matters in terms of the issue to be considered. So Stephanie mentioned a ready reckoner that can be viewed for current prosecutions. Can you please repeat the name of the resource website? Yes, that's, if you go, it's the HSE's website. So on their website, look up the news and page, and on there is press releases. So they have their press releases section. You mentioned the timescales in relation to cases getting to court from the start point of the investigation. This is something that we may see decrease in the future, and is it really down to HSE staffing levels? Do I see that decreasing? No, unless there is a significant influx of inspectors. I think having the opportunity of recovering their their time through fee for intervention has allowed, I think, a certain proportion of cases which inspectors are investigating to be put into the box which is, I won't prosecute that. I'll just recover my time through fee for intervention and we'll move on to something else. If that trend essentially has the effect that the more significant, larger cases are the only ones that are prosecuted, then we may see a decrease in the amount of time taken to see prosecutions in the more significant cases because less are being prosecuted, in a sense. But again, time will tell. My instinct is, for the time being, I can't see them being taking less time. Are these levels of fines significantly higher than what would have been seen previously? Yes. I did some analysis in terms of fines in 2013, 2014 and 2015, and there was a clear tracking already. The effect of the imminent guidelines on the horizon had already seen the level of fines increasing broadly about a double from between 2013 to 2015 is what we saw. So I do anticipate that we will see that continue to track upwards. My analysis was that based upon the guidelines as they're set, we would be typically expecting a 4 or 5-fold increase for the large companies in terms of their fines. And that I don't think we're there yet, because I think in any reading, to go from 500,000 to a 2.5 is quite a big step up for the courts. However, I think we will see that track upwards as the courts start to get a bit more confident. Okay, so that's half an hour. I've pretty much only covered half of one of the slides, which I suppose is means I've got a bit of a wiggle on a little bit. So I'll touch upon now fee for intervention, the regime. It's important, fee for intervention in a number of ways. One, it has created a ready, available antecedent for the HSE in terms of the companies that they are needing to intervene with. Yes, true it is that their own sort of coin system where they could press a button and identify which inspectors have been out to which companies. However, when you have a half a dozen or a dozen or so notices of contravention over the period of the last 2 or 3 years, it creates a thread, it creates a history on an employer or an organisation, which is naturally going to have an effect upon the views of an inspector or inspectors of that company. I'm trying to be as objective as I can. If I know that I'm about to go out and visit an employer, or I have been out and I've seen something, I then come back, or I look in advance and I see that this particular employer has had a history of certain issues, I may look for those issues when I go out on my visits, or I may reflect upon what I've found, and I may take a slightly different view of what I found in terms of its severity, or I might take a different view in terms of what I need to do going forward. So fee for intervention is almost it's an escalation of the letters that used to be sent out giving a bit of advice, to the point where it's contraventions being found, material breaches, and I think that escalation is going to create some issues for the inspectors in terms of how they ultimately are going to deal with multiple notices of contravention that they find. It's compounded. The issue is compounded by virtue of the lack of what I would regard an independent appeal process, and it's an issue shared by a solicitor on behalf of a client, and they have brought a judicial review in relation to the lack of independence of the query dispute process. I believe that's still going in the High Court. I believe the HSE are due to reply back to the applicant in that review to essentially to say to them this is what we're proposing to change in order to halt the judicial review. So the current status of that, I don't know the precise where it's up to in terms of timelines, but I do know that it is something that we're expecting to hear in the next month or two or so. So that is going to be clearly rather important to see exactly what changes are being proposed. One of the things which does trouble me as a defendant lawyer is the crossover between a notice of contravention being issued and the ongoing investigation by HSE, or often in conjunction with the police following a fatal accident. So typically under the old regime without FFI, an inspector would undertake the investigation, and I'm sure those of you who have heard these words before, they'll often say, look, I can't tell you where I'm up to, I can't tell you whether or not what my findings are yet, but in due course, once I've concluded matters, I'll pull my report together, and if we feel like you may have committed an offence, we'll invite you to an interview. That was what we all grew up with, as it were. Now, in order to preserve the opportunity of recovering their time under FIFA intervention, we are finding inspectors feeling the need to write to a suspect or somebody who's being investigated by them to say, look, I think I've already found a material breach. I think I've already seen this, and because of that, I'm serving you notice of contravention. So whilst their investigation is going ahead, they already have, in a sense, taken their own view on whether or not there has been a breach of health and safety legislation. And I can't help but think that creates a bit of a dilemma, really, not just for the employer. How do they react to that notice of contravention letter? Do they say, well, we disagree completely? Or do they say, okay, fair cop, yes, we accept that, and as a result, rather making an admission? It's a dilemma for the inspector himself or herself, in that their position, they are a bit essentially nailing their claws to the mast. They are saying, in this regard, I believe there is a material breach. Now, what if are they going to be bound by the letter which they write? So if they say, for example, notice of contravention, in that you failed to do X, Y, and Z, do I hold them as a defendant lawyer to X, Y, and Z in due course? What if actually they come back and they prosecute, and they also prosecute based upon A, B, and C? Do I say to that inspector, well, why didn't you say A, B, and C at that time? Surely you must have seen that. Surely you must have observed those, and the fact that you didn't meant that clearly you didn't have that view then. So what's changed? So there is a tension, I think, between the need to be transparent on the part of the inspectors in saying they believe there's a material breach and it's in this regard, and the ongoing independent, open-minded investigation which they are required to undertake as a regulator. So I think that is something which I think we may see borne out in perhaps some defences which are brought by employers in due course. We may see FIFA intervention, notice of contraventions being introduced as part of an overall sentencing discussion. So the level of culpability, well, in this particular case, Your Honour, level of culpability is medium to high. And the reason we're saying that is because on previous occasions we have found, the HSE has found some contraventions in other parts of the company which are broadly similar. So that's why we believe it's medium to high. And defendants teams say, well, hold on a second, those aren't being prosecuted, those are just material breaches which we didn't agree with. That's not part of this prosecution. Prosecutions say, well, we think they are, etc., etc. You get my point. So FIFA intervention in those circumstances without an independent or a satisfactory query dispute process, where I think you all are aware, but if not, you're going to be aware now, you're not afforded the opportunity of having an oral hearing. So you can't attend in front of the panel and say, this is why we believe there was not a material breach. Which doesn't feel right to me, particularly if actually that may well have an impact in terms of the amount of money being recovered or charged for, often in the four figures. But also it may have an impact in due course in terms of sentencing and a decision of a regulator to prosecute. So FFI regime is an interesting ongoing subject matter. Okay, quickly now, I wanted just to touch upon some post-incident issues that we're starting to see in the legal community. Anything which is a significant event, we are seeing an increasing amount of reputational damage being occasioned. We saw, and it was very clear to see the different approach being utilised in the Thomas Cook, I just call it the Thomas Cook case, and the Alton Towers case. Thomas Cook, of course, broadly as a result of the inquest and the MD refusing to answer questions, it was a huge backlash. But then it got worse by virtue of how they continued to deal with that. They got worse, and in fairness to them, it wasn't really that unusual in that their insurance company sought to recover the losses which they had incurred and claimed them back from breach of contract from the hotel operators. Now that's a pretty usual set of circumstances, but it found itself, of course, into the press that Thomas Cook managed to get £3 million, whereas the family got peanuts compared. Which is essentially it was the media looking for the story. They'd identified they didn't like Thomas Cook. They'd identified that they needed to try to print some newspapers to get a bit of noise, and that allowed them to continue the story. They're allowed to continue the story again because of the inability of the PR machine for Thomas Cook to get a hold of it and to manage and deal with that effectively. Alton Towers is a completely different set of circumstances, of course. Immediately following the incident, the board were very clear in terms of coming out and saying anybody injured, they will be compensated. They put to one side any legal issues that they may have and any compensation issues, and said, you know what, we're going to do the right thing here because we need to make sure our customers know that we deal with these things properly and effectively. So the Alton Towers identified who their stakeholders were straight away, and they played that through very successfully, in my opinion. They may well still get prosecuted, but given how they had set their stall out from the outset, a prosecution will not feel anything like what it could have done. And more importantly, they have preserved their business and the reputation of their business far more effectively. Dealing with the media is a real challenge in any health and safety case because human beings are affected more often than not. Fathers may have been killed, daughters, etc. There's some huge human emotions at play. And of course, when that happens, it creates a story and a background story. And it's very difficult to tackle that. The one easy piece of advice that anybody could give in these circumstances is, for goodness sake, do not go no comment. There is always something that can be said. Preparation is the key when it comes to how you deal with these matters. You will anticipate that a properly prepared media strategy, whatever crisis you're going through, will have already identified who does speak to the media, who doesn't speak to the media, how you go about preventing stories leaking through your staff being doorstopped. So it's really very important, in my judgment, for employers, organisations to have an enhanced media containment protocols for health and safety, environmental, any regulatory intervention. It's particularly important to have those in play. And as I say, it's something which often can be the difference between being prosecuted and not being prosecuted, particularly if you're able to appease those stakeholders who may well be more vitriolic otherwise with the regulator. Okay, just a few final points before I review some of the Q&A and the questions. Corporate manslaughter cases versus individual prosecutions. We were fortunate to have at the Health and Safety Lawyers Association conference about 6 months ago, actually 3 months ago now. lady who heads up the special crime team in the CPS in the south. And you'll have seen, no doubt, a number of cases already where corporate manslaughter cases have been brought and individual manslaughters against the directors. And the directors, not wanting to go to prison, have instructed, in inverted commas, their company to plead guilty and have essentially done a deal with the prosecution whereby their manslaughter case is dropped. Net result is the company gets a significant fine, which of course impacts the directors because it's probably their money they're not going to make that next year or 2 or 3. But more importantly, they don't go to prison. And what the CPS have said is that their policy going forward is where a company, in most cases the smaller companies, but of course those are the ones that are the only ones really that are being prosecuted for corporate manslaughter these days, small companies. So where you've got a small company and the directors are limited and the failures of those directors are essentially very easily identifiable, then the CPS are looking at prosecuting just the individuals and not the company. And that is to avoid any essentially duplicitous summonses, but just against the individuals. So that their preferred option, I should say, is the individuals being prosecuted, not the corporate. So that it may well be that we see less corporate manslaughter prosecutions and more individual gross negligence manslaughter prosecutions against directors and managers and such like. And that may well even play through in the context of we can just prosecute the company for a health and safety offence because it's going to get a very significant fine anyway. So what is the point in pursuing a more trickier corporate manslaughter case than a health and safety case? You'll have seen last week the conclusion of the hospital trust who was being prosecuted for corporate manslaughter. The judge directed that they essentially kicked out the case at half-time against the trust for corporate manslaughter. And it's a reminder of how difficult it is for corporate manslaughter to be proven against larger companies. The senior management test is harder. The level of gross negligence across the piece is harder because larger companies do tend to have more corporate governance in place and policies and procedures. So we may see more individual prosecutions rather than corporate manslaughter. The last point I wanted to make at 17 minutes past 1 is the sentencing regime doesn't just look at employers' organisations, it looks at individuals. And one of my observations that I have is that the matrix, the guidelines for individuals where there has been a fatal accident, or essentially it's a category of harm 1 with a medium culpability. So it's midpoint, serious case, but midpoint. The starting point in those cases is 26 weeks custody. Now, if I'm being entirely honest, I didn't expect the sentencing guidelines to represent a step up in sentencing against individuals. I did expect it to be a step up against larger companies. Now, it may well be that we'll see flowing through that, the starting point might be 26 weeks in custody, but that's going to be reduced more often than not hitting the custody threshold, and we'll see the same number of people going to prison for health and safety cases as what we have always seen, i.e. relatively few, unless it's manslaughter. But time will tell, and I admit, I'm going to say this is my last point really. It is interesting that now when a client approaches me and says I'm being prosecuted personally, okay, what was the circumstances? Well, there was a very serious injuries, or there was somebody was killed. What's my worst case scenario? Then I will be saying to them, well, worst case scenario, you'll be going to prison, and they'll say, okay, what do we have to consider? Now, under the old regime, I would have said, well, the chances are you're probably not going to go to prison, but it'll be this and it'll be that, etc., etc. Now, what I have to do is show them the guidelines and say, well, this is where he'll start from, or the judge will start from, 26 weeks. And at that moment, it's a real game changer, because I have to talk to the client about the potential of prison. Whereas previously I would have moved over that relatively quickly, because actually we weren't seeing that many individuals in health and safety cases being sent to prison. Now I have to talk to them and say, well, the guidelines are they're sort of starting there. So that is a worry, and I don't know whether we'll see an increase in the number of people being sent to prison. Time will tell. Okay, so if I'm not mistaken, that's the slides I wanted to cover through. So if you just bear with me a moment, I'll just go through some of the questions. To what degree will historical health and safety in organisation be taken into account? Well, I think it will, Keith. I think there will be, certainly where it's easily a due diligence exercise through notices of contravention, for example, that will easily tell. Of course, previous convictions will be known to the prosecution, so that will escalate fines. John Gamble, with regards to corporate manslaughter, will the number of cases increase, especially in sections section 37 and 36 and 37? I think we'll see more cases of 36 and 37 rather than corporate manslaughter, and I think we'll see more individual gross negligence manslaughter instead of corporate manslaughter for the reasons I've just given. Quite a lot of questions here, so bear with me. But surely once the door is open to HSE, don't they start really digging? I'm not sure, Karen, where you're coming from there, but I think obviously once the HSE are in, then they're under obligation to. Has the FFI damaged the working relationship between industry and the HSE? Well, my personal view is that it from speaking to clients, yes, it has. The extent to which it's damaged it is obviously the more relevant question, or the more important issue. But I can't help thinking that anybody, if they're honest with themselves, are going to say, well, do we want the HSE to come in on a regular basis to talk to us when they might charge? I think most people would say, well, we still want them to come in occasionally, but we want to see them less because they might charge us. Regarding sentencing guidelines, how far down the corporate tree will the sentencing affect, e.g. supervisor is culpable for telling an operative to do something that causes injury, as well as corporate, will the increased fines affect the individual? Will sentencing guidelines mean that more individuals further down the chain get prosecuted? I don't think so. I think what is an interesting question is, will the sentencing guidelines have an impact upon individuals who may not have been prosecuted, but may have been regarded as being tainted internally by the company? So if you're a construction director and on one of your sites there's a fatal accident, you may not get prosecuted, but the board will turn to the construction director and say this has been a fatal accident, and it's very difficult for that construction director for the next couple of years to disassociate himself or herself from that particular case, and particularly if it results in a multi-million-pound fine. Equally, it could reflect upon the safety function as well. If they all of a sudden, instead of having a £250,000 fine, you're looking at a £1 or £2 million fine, it rather increases the stakes. So where the stakes are increased, I think the impact felt by those associated will be felt a little bit more keenly. Okay, I'm just going to go to the bottom of the questions now, because we're approaching the end. With cases now probably lasting longer, do we think this will have to lead to the HSE having to employ more inspectors? Alternatively, the HSE send more cases to external solicitors, or HSE recruit more solicitors into their legal function in Bootle. Those are all options. With regards to a group versus limited company query, can this be looked at with a view? Oh, I just lost it. Can this be looked at with a view to incident within the group overseas that is similar? Yes. We've already seen that, actually. The case called Bodycoat, where there was a similar case, the similar incident in the US to what they were prosecuted for in the UK, and the Court of Appeal handed down a larger fine because of what had happened overseas. James Eastham, do you believe that the HSE are looking for opportunities to serve notice of contravention? We have found that in previous years we would have around 10 unplanned visits from HSE that resulted in no further action. We now receive a notice for every visit. Well, Are they looking for an opportunity to serve notices of contravention? I'd, I'd like to think not. I'd like to think that they're going with an open mind to look at an employer and check. But ultimately, I'm a realist, and I also know that if I'm an inspector and I found failures, then I know I have to serve a notice of contravention. And I know that if I only find a notice of contravention in 1 in 4, but everybody else on average is finding it in 1 in 2, or 2 out of 3 of their visits, then is somebody going to look at me and say, why are you being too lenient? I think that is, that internal peer pressure could well lead to some inspectors feeling that they need to go and just give something, rather than being overly lenient and being essentially criticised for being overly lenient. So I think that is something that we can realistically expect. But as I say, it's awful to think that inspectors are going to go with a closed mind, i.e. turn up on site and say, I'm going to find something here, I've got to find something here because I need to recover my time. And I hope that we don't see that. But again, on the flip side, human instinct. We received Emma Curry, we received an NOC working at height, and the HSC decided not to prosecute due to our proactive improvements in discussions with the M2 who argued best practice. So it is possible to avoid prosecution for material breach. I agree. And I think it's the point I made before that fee for intervention does provide an opportunity for the HSE to say, well, look, we've spent a bit of time with you, we're going to serve you with an invoice for a couple of £1,000 or more or less, but we're not going to prosecute because we're satisfied about what you've done. Of course, if that happens again, then you've had your warning, you've had your yellow card. So it may well be that you're going to have to be careful when you're having similar-ish offences, particularly if you're part of a wider group. There are lots of questions, and I'm sorry if I haven't been able to get to everybody's questions in time. I'll try and I'll pick one more just because I am conscious of time, and Ben will be dialing in at no doubt at some stage to say we're nearly done. I've already done that. Ian's one, Julian Sanders. Do you think this will have a profound effect for individual health and safety consultants for their clients' failure to perform adequately with regard to health and safety? I'm guessing, Julian, that what you're asking there is with bigger fines, with more at stake, inevitably either consultants are going to be employed, or where they have been employed, questions are going to be asked about the advice that was given. Equally, I think with the threat of more significant fines, I think it's also true that steps taken following the accident or the likelihood of harm, if there is no incident at all, will be taken into account by the court. And so if you're talking about it, throw a lot of mitigation as best you can at it, and therefore if you've got a program of improvements that you have commissioned by your internal consultant team or by your external consultant team or both, then that's obviously going to be useful mitigation for any of your legal team to deploy. And it may be something which the prosecution make reference to as part of their case anyway, and making concessions. So I think it's going to be multi-layered. I think yes, it can have an impact upon those people whose job it was to prevent the accident taking place. They might get a bit of heat, but equally once it's all done and dusted, and we're looking at mitigation, I think there will be a desire to introduce as much mitigation as possible. Reminding me about legal privilege and accident reporting. I'll finish off on this. Okay, legal privilege in very simple terms. If you anticipate that something may result in litigation, i.e. prosecution, then the things which you undertake, taking legal advice or things which you prepare, accident investigation reports and such like, with a view to taking legal advice, attracts legal privilege. What doesn't attract legal privilege is documentation which you were going to prepare anyway as part of your policies, no intention of taking legal advice on it. However, if, as I say, you are intending upon taking legal advice because you know, and your spider senses are tingling, as a client says to me, my spider senses are tingling, Steffan, I've got a bit of a problem about this one, what do you think? I'd like you to have a look at it. And I will say to that individual, okay, I want you to pull this report together. I want you to speak to Johnny, Billy, and Sarah. I want you to get some statements together, and naturally, and therefore, that documentation as pulled together for my benefit to give legal advice does attract legal privilege. Very useful because you can get your warts and all, knowing that actually it is protected from being handed over. So I'm pretty sure, Ben, that I am now pretty much finished. I think in the circumstances, I'd like to thank everybody for their time and attention. Hopefully you found this of interest. If there's any questions, then by all means feed them through to Ben, and I don't know whether Ben will collate them. But I say, I'd like to thank you everyone for your time, and best of luck, and hopefully you don't need to use DWF, but if you do, then I'd obviously help you as best I'm able to. So good afternoon everybody, and goodbye.
Okay, thank you very much for that, Steffan. As he said, we'll leave the chat open for a couple more minutes now, just so if you've got any final questions you want to post through, you can do. I will be collating those into a document, and Steffan hopefully will be able to, at some point over the next couple of weeks, go through those and provide us with some written answers to any of the questions that he wasn't able to answer during the session. I hope you've all enjoyed the session. I thought it was very informative. Obviously, if you do have any further questions, you can email me. I will be emailing all of you very shortly with the various links and confirmation of your attendance. But if you do have any further queries at all, don't feel free to just get in touch with me. My email address is ben.pollard@iosh.co.uk. Excellent. Okay, thank you very much. I'll leave the chat show open now for another minute.